mute your screens for the time being. I will be pleased to take questions, but I propose to do that at the end of the talk. Contributory negligence in clinical negligence cases. What is the position of a claimant who has acted unwisely and injured their health as a consequence, is then admitted for medical treatment, which is negligently delivered, and their condition fails to improve? The issue that I want to explore is, to what extent is their original fault deemed to be a cause or a contributory factor to the final outcome? It's a relatively common scenario in clinical negligence cases. The reckless driver who, after a road traffic accident, receives negligent paramedic care, or the drunken Saturday night brawler who, following a fight, then receives negligent care at the accident and emergency department, or the persistent smoker whose diagnosis of cancer is then missed. In ordinary personal injury litigation, arising out of, for example, a road traffic accident or an accident in the workplace, it happens frequently, almost more often than not, that a claimant will face allegations of contributory negligence. But in clinical negligence cases, such allegations have traditionally, at any rate, been rare. And why is this? Is it for legal reasons? Is there something about the statute which sets out the principles of contributory negligence law which prevents it? Or is there precedent, case law, preventing contributory negligence contentions from being made? Or is it for reasons of paternalism, the traditional view of the doctor-patient relationship? Or is it for reasons of public perception? After all, it's a pretty unattractive position for a doctor to adopt, to injure one of his patients, his or her patient, and then allege that the patient is responsible, at least in part, for the ongoing adverse condition. What I propose to do is take each of those four topics and look at them in turn, and assess where we are in relation to contributory negligence within the clinical negligence context. The starting point is the 1945 Act, which provides that where any person suffers damage as a result partly of his own fault and partly of the fault of any other person or persons, the damages recoverable in respect thereof shall be reduced to such extent as the court thinks just and equitable, having regard to the claimant's share in the responsibility for the damage. Arising out of that section, the following questions fall to be considered. Firstly, was there fault on the part of the claimant? Secondly, if so, did the damage or injury which he or she has suffered result partly from that fault? Thirdly, what was the extent of his or her responsibility for that damage or injury? And lastly, what is the reduction in damages recoverable that is just and equitable? So far as the issue of fault is concerned, the authority of Reeves that you see on your screen now, about 6 lines down, it reads as follows: "It is perhaps unfortunate that contributory negligence is called negligence at all. Contributory fault would be a more descriptive term. Negligence, as it is commonly understood, is conduct which creates an undue risk of harm to others. Contributory negligence is conduct which involves an undue risk of harm to the actor himself. Negligence requires a duty, an obligation of conduct to another person. Contributory negligence involves no duty, unless we are to be so ingenious as to say that the plaintiff is under an obligation to protect the defendant against liability for the consequences of the plaintiff's own negligence. Froome versus Butcher makes the position simple and clear. It's an authority from Denning, and what Denning said was contributory negligence is a man's carelessness in looking after his own safety. It's as simple as that. You will be familiar with the case of Jones against Liverks from your law school days. You'll remember that that was the case in which the claimant had written on the back of a vehicle in a construction site something called a traxcavator, thereby exposing himself to the risk that he might be thrown off and injured. Another vehicle then ran into the back of the vehicle that he was on, and the claimant was injured. He contended that his damages should not be reduced because although it was foreseeable that he might be thrown off the first vehicle, it was not foreseeable that he would be injured by another vehicle running into him. The Court of Appeal, the Court of Appeal rejected that contention. And again, what Lord Justice Denning, as he then was, said, just as actionable negligence requires the foreseeability of harm to others, so contributory negligence requires the foreseeability of harm to oneself. A person is guilty of contributory negligence if he ought reasonably to have foreseen that if he did not act as a reasonable, prudent man, he might be hurt himself. And in his reckonings, he must take into account the possibility of others being careless. In the context of clinical negligence claim, should one foresee, in the context of clinical care administered after a personal injury, should one foresee the possibility of one's treating doctors being careless? Does that action fall within the concept of reasonable foreseeability? Well, the answer, it seems to me, is provided in the authority of Webb against Barclays Bank. And again, you'll remember that in that case, the claimant fell in the defendant's bank premises due to the bank's negligent maintenance of its forecourt. The claimant suffered a knee injury and consulted a surgeon at the hospital. At the hospital, the surgeon acted negligently, and ultimately the leg was amputated. The negligent defendant bank claimed that the negligent actions of the hospital was an intervening cause and broke the chain of causation. The Court of Appeal concluded that an exacerbation of an injury caused by a subsequent medical treatment may, in the Court of Appeal's words, easily be considered a foreseeable consequence for which the first tortfeasor is liable. And you'll remember that in that case, the chain of causation was deemed only to be broken in circumstances where the intervening act of negligence by the clinician was properly categorizable as gross. A couple of points in relation to matters arising when a court is satisfied that contributory negligence exists. The first is that according to the authorities of Badger and Boothman, and Badger is the case we're going to come back to at the end of this talk, those cases are authority for the proposition that once the claimant has been found at fault, the requirements of the 45 Act mean that a reduction in damages is mandatory. And the authority of Boothman suggests that there is no place for the principle of de minimis non curat lex. In relation to the extent of reduction in damages which should be made, again, it's the authority of Badger, which just makes clear that it should be done in a broad, jury-like and common sense way. In relation to practicalities, in order for a court to make a finding of contributory negligence, it needs to be properly pleaded in the defence, and the burden of proof remains at all times on the defendant making the allegation. Before turning to what use the courts have made of these principles in the context of clinical negligence, I want to look at an important authority which is often used as the starting point. George against the Home Office, the claimant was a 29-year-old when he entered prison. He had been abusing alcohol and drugs since the age of 16. He informed the prison staff that he was a heroin user who drank heavily and had previously had alcohol and drug withdrawal seizures. Unwisely, the prison authorities, in allocating the claimant accommodation, allocated him a top bunk bed. A few days later, he suffered withdrawal seizures and fell from the bed, suffering a head wound. The seizure developed into status epilepticus, and he sustained severe brain damage. The judge at first instance looked at information about the claimant and his background. The judge said that he came from a good family, he'd made a promising start in life, but that sadly at the ages of 15 or 16, he'd started using drugs, causing him to drop out of school, acquire other addictions, and life then spiraled out of control with stealing and sentences of imprisonment. At trial, breach of duty on the part of the prison service or the Home Office was established for the bed that they had provided him with, and the issue of contributory negligence was raised, the arguments resting on the lifestyle choices that the claimant had made prior to his coming into prison. The trial judge decided that the claimant was at fault in choosing a lifestyle of drug and alcohol addiction when he was a teenager, and he expressed himself in the following way. Viewed objectively, as it must be, in my judgment, the claimant has to be described as being at fault in relation to the choices he had made in his life prior to the events of this night. That fault has caused or contributed to the dreadful injuries in this way, not because they have put him in prison, but because he was knowingly risking injury to his health by doing what he was doing, even if he did not know how it would happen. And at first instance, damages were reduced by 15%. The case went to the Court of Appeal. The claimant argued that the damage he had suffered was not the result of any fault on his part, and in the alternative, it would not be just and equitable to reduce his damages having regard to his share in the responsibility for his injuries. The Court of Appeal reversed the ruling on contributory negligence, and at paragraph 47, Lord Justice Dyson said, "In my view, the judge was entitled to hold the claimant was at fault in becoming addicted to drugs and alcohol when he was 15 or 16 years of age. He was entitled to infer that the claimant must have known at that time that the abuse of drugs and alcohol on the scale necessary to lead to addiction was dangerous to his health." And the Court of Appeal then went on to find that it was correct that but for the addiction, the claimant would not have suffered a withdrawal seizure, would not have fallen from the top bunk and suffered the head injury. In that sense, said the Court of Appeal, his injury was the result partly of his addiction. Nevertheless, the court went on to say, "In my judgment, the claimant's fault in becoming addicted to drugs and alcohol in his mid-teens was not a potent cause of the status and the consequent brain injury which were triggered by his fall. It was too remote in time, place and circumstance and was not sufficiently connected with the negligence of the prison staff, was not sufficiently mixed up with the state of things brought about by the prison staff to be properly regarded as a cause of the injury. To use the language of Lord Justice Denning, the claimant's addiction was no more than part of the history which had led to his being a person whose medical and psychological conditions were as they were when he was admitted to Brixton Prison." And Lord Justice Dyson went on to draw an analogy with the case of a claimant who seeks medical treatment for a condition from which he is suffering as a result of his own fault and sustains injury as a result of the negligent treatment. Examples of such condition are lung cancer caused by smoking or cirrhosis of the liver caused by excessive consumption of alcohol. Mr. Kent, who was one of the counsel in the case, accepts that in such cases, it would be wrong to reduce a successful claimant's damages under the 1945 Act. One of the reasons why I consider Mr. Kent is right to make this concession is that the claimant's fault in smoking or consuming excessive alcohol over a period of time is not a potent cause of the injury suffered as a result of the negligent medical treatment. The fault is not sufficiently closely connected with the defendant's negligence. Rather, the fault is part of the claimant's history, which has led to his being a man who is suffering from a particular medical condition. Now, others have questioned whether counsel in the case, Mr. Kent, was right to make the concessions that he did. What appears to be clear is that it was a concession made without consideration of some of the relevant authorities. And at paragraph 40 in that authority, it says, this cross appeal raises a point on which, as I have said, there appears to be no previous authority. And it is now to those authorities that I turn. The first is the case of Pigeon against Doncaster. A 22-year-old attended her GP in Sheffield and a cervical smear was taken. The smear was mistakenly reported as being negative, and 9 years later, the claimant, Miss Pigeon, was diagnosed with cervical cancer. Over the intervening 9-year period, Miss Pigeon had received numerous urgings from both her general practitioner and the health authority to have further smear tests taken. And she had refused to undergo those tests as she found the tests to be painful and embarrassing. And that was against a background of her being told that the original smear, which was misreported, had given her the all clear. So she was ignorant in relation to that aspect. The health authority was found to be in breach of duty in the evaluation of the original cervical smear test. The health authority made allegations of contributory negligence on the part of the claimant for failing to attend the regular screenings in the following 9 years. The trial judge found that while the fact that the claimant found the smear tests embarrassing and painful should not be ignored, it should not, on the other hand, be overestimated. The claimant had undergone a number of previous intimate medical examinations. The claimant understood the purpose of the tests, so the judge found, and understood that a failure to attend or refusal to have such a test carried certain risks. To fail to attend once in 1991 was blameworthy, but to again fail in 1994 was doubly so, considering the terms of her warnings from her GPs. And in the circumstances of that case, the claimant was found 2/3 responsible and only entitled to 1/3 of damages. We then fast forward to 2016, the case of Zeb and Frimley, and this was a judgment of Mr. Justice Garnham, who was presiding over an appeal against an application for an interim payment. Miss Zeb moved to the United Kingdom from Pakistan. Within a fortnight of her arrival, she had visited the Wexham Hospital Accident and Emergency Department on 2 separate occasions, complaining of headache, abdominal pain, and chest pain. During those attendances, she said, she told the clinicians that she had in fact undergone previous investigation in Pakistan, which had been normal. In the month after those attendances, Miss Zeb was diagnosed with TB meningitis, which caused devastating neurological injuries. By their original defense, The defendants admitted that the claimant should have been admitted to the A&E department, that a timely diagnosis of TB meningitis should have been made, and that had that happened, Ms. Zeb would have made a full recovery. The case then proceeded to the disclosure stage, and the disclosure included evidence that 2 months prior to the claimant's arrival in the UK, she had been diagnosed with probable TB meningitis, for which she had been prescribed a 1-year course of treatment. The defence was then amended to make allegations of negligence against the claimant, firstly in failing to continue with the course of treatment prescribed in Pakistan, and secondly in failing to draw to the attention of the defendant's clinicians at the A&E department her recent history. Mr. Justice Garnham said, paragraph 30, on contributory negligence, I have no hesitation in rejecting Mr. Kelly's argument that because the claimant attended the hospital and put herself in the hands of experienced clinicians, there can be no contributory negligence. The need for an accurate history from a patient is fundamental to any medical assessment, especially in circumstances such as the present. And then at paragraph 34, if it is right that the claimant received a probable diagnosis of TB in Pakistan a few weeks before she travelled to the UK, with prescribed treatment, both for the first 10 days and then for the following year, and that she failed to take that treatment or request its provision, that she was asked to pass the referral letter to subsequent treating clinicians and did not do so, and when asked at Wexham Park Hospital whether her recent tests in Pakistan were normal, she said yes, then it seems to me that at least arguably she was negligent. What is more, that negligence occurred not just in Pakistan, but continued when she reached the UK and when she visited Wexham Park Hospital. In those circumstances, the judge found that he couldn't be satisfied that come the trial, the claimant would be awarded the damages which was necessary for him to find that she would be awarded before making an interim payment. Spearman against Royal United Bath is a 2017 authority. Mr. Justice Spencer, the claimant in that case had suffered a hypoglycemic attack, taken by ambulance to the Royal United Hospital in Bath. Within 15 minutes of the claimant's arrival at the hospital, he had left the emergency department of the hospital, climbed 5 flights of stairs to a flat roof, climbed over a protective barrier, and either fallen or jumped into a courtyard below where he suffered serious injuries. It was established that the hospital was in breach of its duty to the claimant in relation to how the premises were laid out. The Trust nevertheless went on to make allegations of contributory negligence. Now, it's right to say that most of the allegations of negligence were given short shrift by Mr. Justice Spencer, but in the course of his judgment, he did say that it might be contributorily negligent for a patient to discharge himself from hospital if he thereby deprives himself of treatment or investigation which he needs, and thereby sustains harm or additional harm from the lack of treatment or investigation. Now, in addition to these limited authorities in the United Kingdom relevant to contributory negligence in a clinical negligence context, there are a number of relevant authorities in the Commonwealth jurisdictions, most notably Canada. The case of Zhang was one such Canadian case. Sherry Fung was a child born with Down syndrome. Her mother, the claimant, Miss Zhang, was around about 40 years old at the time of Sherry's birth. During the pregnancy, Miss Zhang, the claimant, had learned from her Hong Kong doctor, Dr. Ling, that because of her age, she was at risk of having a child with Down syndrome. The claimant had done significant research herself in relation to that issue, reading pamphlets, books, and a brochure. And it was in those circumstances that she spoke again with Dr. Ling, her Hong Kong doctor, to arrange an amniocentesis. For medical reasons, the procedure in Hong Kong was postponed. Miss Zhang wanted to have the baby born in Canada, and it was therefore determined that the way forward was for her to go to Canada and for the test to be done in Vancouver. The claimant went to Canada and consulted the defendant, Mr. Can. Mr. Can told the claimant that it would be too late at that stage for an amniocentesis, and the chance of having a baby with Down syndrome was significantly less than she had been led to believe. Miss Zhang, the claimant, left the office questioning the advice that Mr. Khan had been provided because of the conflict of because of its conflict with the advice that she had received from Mr. Ling and with what she had read. Subsequently, Sherry was born with Down syndrome. Now, at the trial, the defendant was found negligent for failing to take steps to arrange an amniocentesis following her arrival in Canada. Contributory negligence was raised, and the judgment of the court included the following. Miss Zhang, the claimant, is a sophisticated and experienced businesswoman. She had researched the topic of amniocentesis as she knew that at her age, she was at high risk of bearing a Down syndrome child. She had already discussed the need for the procedure with her Hong Kong doctor. As far as she was concerned, when she came to Vancouver, the question was not whether she would have an amniocentesis, but when. Miss Zhang said that she doubted Dr. Can's advice that it was too late to take the test. She knew from what she had read and from what Dr. Ling had said that it was not too late for the amniocentesis. She agreed at trial that she could have turned around and gone back to Hong Kong and taken the test. She could certainly have sought out another doctor. In my view, Miss Zhang must share the responsibility for there being no amniocentesis undertaken during the high-risk pregnancy. After the first visit to Dr. Can, the couple knew there might be a problem if there was no amniocentesis. I assessed the plaintiff's contributory negligence at 50%. There are then two other authorities from the Commonwealth that I've done slides for. Brushett and Cowan is one, and then Crossman and Stewart is another, in which again the claimant has been found culpable for contributory negligence in the clinical negligence context, and damages reduced accordingly. What this case law suggests is that in appropriate circumstances, a claimant can be found contributory negligent in respect of culpable conduct where that conduct occurred before the negligent medical incident. That's the cases of Zeb and Crossman. At the time of the negligent medical incident, that's the cases of Spearman and Zhang, and culpable conduct which occurred after the negligent medical incident. That's the cases of Pigeon and Brushett. So why, in those circumstances, have there been so few reported cases of contributory negligence in a clinical negligence context? And it has been suggested that at least part of the reason is as a consequence of the historic view of the doctor-patient relationship, which has been viewed as a paternalistic relationship, where a patient looked to the doctor to make everything right. The doctor assumed a responsibility to deliver in the same way as a child looks to a parent. The doctor has traditionally played a parental role and the patient traditionally the role of a passive child. But that traditional view has undergone significant evolution, and it's the case of Montgomery which marks that. Lord Kerr's judgment in that case reads as follows, paragraph 75. Since Sidaway, however, it has become increasingly clear that the paradigm of the doctor-patient relationship implicit in the speeches, since Sidaway, however, it has become increasingly clear that the paradigm of the doctor-patient relationship implicit in the speeches in that case has ceased to reflect the reality and complexity of the way in which healthcare services are provided, or the way in which the providers and recipients of such services view their relationship. One development, which is particularly significant in the present context, is that patients are now widely regarded as persons holding rights rather than as passive recipients of the care of the medical profession. Other changes in society in the provision of healthcare services should also be borne in mind. One, which is particularly relevant in the present context, is that it has become far easier and far more common for members of the public to obtain information about symptoms, investigations, treatment options, risks and side effects via such media as the internet, patient support groups and leaflets issued by healthcare institutions. It would therefore be a mistake to view patients as uninformed, incapable of understanding medical matters, or wholly dependent upon a flow of information from doctors. The idea that patients were medically uninformed and incapable of understanding medical matters was always a questionable generalization. To make it the default assumption on which the law is to be based is now manifestly untenable. And then paragraph 80, in addition to these developments in society, and the court then went on to make reference to the Human Rights Act. And then at paragraph 81, it reads, the social and legal developments which we have mentioned point away from a model of the relationship between the doctor and the patient based upon medical paternalism. They also point away from a model based upon a view of the patient as being entirely dependent on information provided by the doctor. What they point towards is an approach to the law which, instead of treating patients as placing themselves in the hands of their doctors, and then being prone to sue their doctors in the event of a disappointing outcome, treats them so far as possible as adults who are capable of understanding that medical treatment is uncertain of success and may involve risks, accepting responsibility for taking of risks affecting their own lives, and living with the consequences of their choices. In a sense, in the Supreme Court's view, we as patients have grown up and entered adulthood. Attaining one's majority means one enjoys greater rights, but also arguably it involves greater responsibilities. I think it was the French Revolution which coined the phrase that with greater power comes greater responsibility. And if that's right, it may well be that the apparent gift to claimants presented by the Montgomery case may turn out to be, at least in part, a poisoned chalice. The last area that I wanted to address was that of public perception. Now, arguing contributory negligence is essentially an effort to shift blame from the negligent doctor onto the unfortunate patient. An unattractive argument, given the fact that the patient will have already experienced some harm, viewed perhaps like rubbing salt into the wound. And in addition to running the risk of arousing further considerable ill feelings from the patient, it also runs the risk of significant adverse publicity. But a reticence to embark on such a course of action with the attendant bad publicity was overcome years ago in the context of personal injury litigation. And I just wanted to draw attention to two notable examples from organisations in the UK, which as public institutions hold positions of trust, arguably analogous to the position of the NHS. The first is the Metropolitan Police Commissioners of London, and the second is the Ministry of Defence. In relation to the Metropolitan Police Commissioners in London, the case of Reeves, which we touched on at the outset of this talk, Mr. Lynch hanged himself in his cell in Kentish Town Police Station. Prior to that, he had made 2 previous attempts at suicide, and on each occasion, the attempts had been done by him trying to strangle himself. On the occasion of his arriving at Kentish Town Police Station, he was reviewed by a doctor who gave instructions that as Mr. Lynch was a suicide risk, he should be frequently observed. In the course of the observations which are undertaken of him, a policeman looked through the open wicket hatch in Mr. Lynch's cell door and saw that he was lying on his bed. That policeman then omitted to close the open wicket hatch, and a few minutes later, Mr. Lynch was able to attach a ligature to the open wicket hatch and kill himself. Now, the trial judge found that the police had been negligent in failing to shut the wicket hatch, in failing to ensure that fittings in the cells should not provide an opportunity for the prisoner to do himself injury. The Commissioner contended, however, that there should be a reduction in damages on the basis that the defendant was partly to blame in taking his own life. They contended that while they had a responsibility to Mr. Lynch also had a responsibility to himself. There was evidence that Mr. Lynch was of sound mind, that there were no grounds for minimizing his share of the responsibility on the basis of some conception of diminished mental capacity. The contribution which Mr. Lynch made to the fatal outcome, so said the Commissioner, was clearly a substantial one. If they were at fault, they argued, well, so was Mr. Lynch. The case went to the House of Lords, and the Commissioner's arguments were in large part successful. Lord Hobhouse's judgment includes the following. A number of principles are involved. Firstly, there is the fundamental principle of human autonomy. Where a natural person is not under any disability, that person has a right to choose his own fate. He is constrained insofar as his choice may affect others, society or the body politic, but so far as he himself alone is concerned, he is entitled to choose. The choice to commit suicide is such a choice. A corollary of this principle is, subject to the important qualification to which I will refer, the principle that a person may not complain of the consequences of his own choices. This both reflects coherent legal principle and conforms to the accepted use of the word cause. The person's choice becomes, so far as he is concerned, the cause. The autonomy of the individual human confers the right and the responsibility. He went on to say, to qualify as an autonomous choice, the choice must be free and unconstrained, a voluntary, deliberate, and informed. And then later, Hobhouse said, if Mr. Lynch, knowing that the police officers had put him in a cell with a defective door and had failed to close the hatch, and then voluntarily and deliberately, in full possession of his faculties, made the rational choice to commit suicide, principle and language say that it was his choice which was the cause of his subsequent death. He was not, on the judge's findings, acting under any disability or compulsion. He made a free choice. He is responsible for the consequence of that choice. So a bold argument, you may think, by the Commissioner of Police, but it was an equal boldness which was shown by the Ministry of Defence in the case of Badger. The claimant was the widow of Reginald Badger, who died of lung cancer. Reginald Badger had been employed by the Ministry of Defence for a period of 33 years. And over that period of time, he had been exposed as a consequence of the MOD's negligence to asbestos dust and fibres, which were causative of the lung cancer that killed him. He also smoked, and there was medical evidence to the effect that that smoking was additionally causative of his cancer. The Ministry of Defence admitted primary liability, but made allegations that the damages should be reduced on account of Mr. Badger's contributory negligence. The contributory negligence was his continuing to smoke when, it was alleged, he knew or should have known that his doing so was liable to damage his health. Now, the judge did an extensive review as to what knowledge there was for members of the public in relation to smoking. And the judge found that in the 1970s, the UK government had begun to issue health warnings about smoking. And the deceased himself had received personal warnings from his GP in relation to the dangers of continuing smoking. And what Mr. Justice Burnton said was as follows: although foreseeability of injury is to be determined objectively, in my judgment, the actual knowledge of Mr. Badger must be taken into account. Foreseeability may be inferred from information available to the public in general, or proved by evidence of reliable advice or information given to a claimant personally. Information and advice given to a claimant personally is even more obviously relevant to the question of the degree of fault, if any, attributable to him. Evidence of public awareness of the dangers of smoking and advice specific to Mr. Badger are not to be looked at in isolation from each other. The evidence specific to Mr. Badger must be considered together with the contemporary evidence concerning general public awareness of the health risks associated with smoking. And then paragraph 46, foreseeability of injury is a prerequisite of fault, but is not determinative of fault. To be guilty of fault, the claimant must have had some reasonable freedom to choose to do otherwise, to avoid incurring the risk that was partly responsible for his injury. Mr. Badger cannot be criticised for starting to smoke. In 1955, the connection between smoking and serious ill health was not widely accepted. If he was guilty of fault, it was in not giving up smoking. I have no medical evidence before me on which I could find that Mr. Badger was so addicted to tobacco or nicotine that he could not reasonably have been expected to stop smoking. I find on the evidence before me that Mr. Badger could have given up smoking. If he could have given up smoking, should he, as a reasonably prudent man, have done so? In my judgment, the answer is yes. A person who continues smoking, who knows or ought to know that by doing so he is damaging his health, or that he risks doing so, must accept responsibility for his actions. A reasonably prudent man, warned that there is a substantial risk that smoking will seriously damage his health, would stop smoking. I've reviewed the four areas that I wanted to look at. As a matter of statute law and common law, it would appear open to defendants in clinical negligence actions to make allegations of contributory negligence. Paternalism, post-Montgomery, is likely to play a diminished role. In relation to the issue of public perception, our trusts and our health boards are the guardians of a state-funded health system with finite resources. They face a future compensation bill for clinical negligence claims estimated to be in the region of £83 billion. And there is concern that there may be a diversion of NHS resources from frontline healthcare towards that bill. And the result is feared to be a restriction or prevention of access to other members of the public for healthcare. It seems that if significant institutions of our state, including the Metropolitan Police and the commissioners and the Ministry of Defence, are prepared to run the risk of adverse publicity by attempting to shift or at least share the blame with a claimant whose negligence they have injured, it may well be the case that the NHS will become increasingly willing to do so. That concludes the talk that I was proposing to give. I said at the outset that I'd be happy to take questions. There is a chat function, as I understand it, from my technical advisor that could be used. But it may well be that given the time and given that people are likely to be on lunch breaks, there's no time for that. And if that is the position, I'm more than happy to deal with any questions by email in due course. But if anybody has any questions they would like to raise now, please go ahead and do so. Much indeed for attending this talk. Hopefully it has provided food for thought. Now I'm just getting a few questions. Sorry, first question. In your opinion, what weight can be given to a claimant's previous medical knowledge, say they were employed medically, when arguing contributory negligence? Well, I think the answer in relation to that is that considerable weight can be given to a claimant's previous medical knowledge. One of the Commonwealth authorities that I referred to is a case where the claimant did have some previous medical knowledge, and that was used against them and informed the finding of contributory negligence against them. Great. Okay, well, as I say, I'm going to draw a line there, but thank you very much indeed for attending. And if I can assist by way of email in due course, please don't hesitate to send me an email. Cheers then. Bye bye.